Let's proceed on to our very first feature for this week, and that is Business and Immigration Law Update. This popular segment is a proud presentation of attorney Ramesh Khurana of the Khurana Law Firm, which is located in the heart of Gaithersburg, Maryland. The moderator on this set is attorney Kenneth Haber from Bowie, Maryland. On the GTV camera today, attorney Haber questions attorney Khurana on filing labor certification for green cards during the 6th year of the H-1B. Let's take a look.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney and I am a former Senior Attorney of the Office of Inspector General, the United States Department of Health and Human Services. I'm here today with Ramesh Khurana, and this is the Capital Forum. Welcome, Ramesh.
Thank you, Ken.
Ramesh is an extremely well-known and well-experienced immigration attorney. He has his practice in Rockville, Maryland, or Gaithersburg actually now, and he practices around the country and around the world by the nature of his practice. Ramesh, are you ready for a few questions?
Yes, I am. Before that, I want to thank you very much for your generous introduction.
Oh, you deserve every word of it, sir.
I appreciate that.
Ramesh, can we turn ourselves to the H-1B visa, because I'm sure that's one that does grab some people's concern and attention. Can a foreign national who's President of the United States on an H-1B status, can he seek anything more than a maximum period of 6 years?
You know, Ken, yes. You know, the standard time for an H-1B visa holder is 6 years. But there are certain situations under which this period can be extended beyond 6 years. So H-1B beneficiaries and the employers have got to know as to what are these special conditions.
What are they?
Yes, I knew you would ask me, and I would be happy to explain.
Please.
Yeah. So first of all, the people would ask me a question like, can we start our green card process during the 6th year? Because they get scared. Nothing happened during the first 5 years of their H-1B visa status, and now the time is running out, because most of them already know that maximum you can have 6 years. And I always say, don't get panicked. You know, now since your employer has decided to file a green card petition starting with the labor certification, so probably let's work on it efficiently and make it happen, because there are two important conditions which would govern regarding extension of H-1B status beyond the standard 6 years.
What are they?
Yeah. Number one is that labor certification request that must have been done at least 365 days before the 6th year expires. So either it should be certified or it should be pending, because sometimes you have an audit, and by the time you file a response to the audit, adjudication is not paid. So 365 days must have gone by before you can get 6th year. And second thing is, when people come really after the expiry of 5 years, and we have to start with the labor certification request, if the labor certification is completed and it is certified, let us say it takes about 8 months, and after that we can file the immigrant petition, which is popularly called as I-140, and if I-140 is filed, this can be filed under the premium processing by paying an additional fee of $1,225, and the decision can be made in 15 calendar days, not even 15 working days, unless USCIS has some follow-up questions which will come to us by way of an RFE, which is called the request for further evidence, and still we can send back those answers, and probably we can have the approval in next 15 days. So there have been situations where we have obtained approvals of I-140 within a period of 8 to 10 months, starting from the beginning, including the labor certification process. And once the I-140 is approved, then there is no request, there is no condition of 365 day applicable, because I-140 is approved. So, based on I-140, the person can file extension in H-1B status for 3 years. If it is not I-140 based, if it is based on expiry of 365 days, when the labor certification request has been pending, then that person can file only for 1 year. So, these are very, very important conditions, and people lose their sleep when they are during the 6th year. But if you know what can be done and your employer is supporting you, this can be accomplished.
Those are rather complex rules. Can an employer file for his employee when the employee is living overseas, or his prospective employee?
Again, just a comment in response to your first observation that those are complex rules. Answer is yes. Immigration law is as complex as security laws and the tax laws. These are very complex, and every day we have to watch what's new happening now, and we have to keep track of that. Otherwise, we will be lost in this complex world of immigration. Believe me.
I would imagine.
Yeah,
It
yeah.
would be easily to go left
Yes.
instead of right, and vice versa.
Right. Now, responding to your second part of the question, which is whether we can start the labor certification process when the person is sitting overseas. The answer is yes. It is not the prerequisite that the beneficiary should be residing here in the United States. Why? Reason is very simple. This is a prospective job. This is a future job, and this is the intent of the employer to hire this potential employee in future. So, it can be filed. It has got nothing to do with the immigration status of the person here.
I see.
Yes.
I see. Can you explain the options and possible outcomes of the labor certification request if it's filed in the 6th year?
Yes. As I explained in response to your first question, that it becomes very challenging and people lose their sleep when the green card process has not been started during the first 5 years. Maybe the person has already bought a house, and they have small kids or kid, and they have become used to the American way of life.
It's a great way of American life.
Yeah, you know that how people are coming here because they just want to have a better quality of life, and they get full rewards of whatever work they do.
Yeah,
so that's the beauty of this.
Sometimes people don't appreciate the life they have here. I'm not talking about people who are overseas coming here,
Right,
but some of the people who are born here don't appreciate it.
Yeah, you are right, because they do not know what is happening in other countries.
That's right.
Especially in the third world.
That's right.
Believe me, everything is an issue. Drinking pure water is an issue, and drinking pure milk is an issue. You get adulterated milk, you get fruits and vegetables which are basically grown based on pesticides, and those are so dangerous for your lives.
I've seen on NKH that the Chinese are buying their milk from Australia because of their concern for the purity of the milk in China.
Right, you're right. So,
NHK.
we are grateful to God we are here in this great country.
Yes.
And we are working hard to pay our bills, and in turn we have a better quality of life for us and for our family. So, yes, during the 6th year, as I was saying, it's very challenging. People start losing their sleep. What will happen? What will happen if 6th year is gone and my labor certification is not done, or even 360 days or 365 days are not complete? Now, again, there is a way out to overcome that kind of situation.
I thought you'd know it.
Yeah, sure. Because we have used this kind of tool in those difficult situations. Let us say that a person is short by 30 days. Now, what that person can do is, now he can go to his home country, or physically he has to go out of the USA.
Like maybe go to Canada visa.
Oh, sure, for this purpose, yes. Because it's a question of physical presence in the United States. And if you are physically absent from the United States, because you do not want to go out of status. That is the first thing you don't want to do. You always want to remain in a valid status. So you go out of the country, so there will be two scenarios. Either if the labor certification is not certified for any reason and it is still pending, if 365 days are gone, you can come back based on 1 year approval, because now your H-1B petition will be filed by the employer and get you 1 year. And if I-140 is approved, then you can straightway come back for a period of 3 years.
Very good.
So there is a solution.
Very good. And I would imagine that that same employee, let's say he was able to go to Canada, he'd probably, especially if he was an IT type of person, could possibly work by the internet. And would there be any prohibition of him continuing to work for the employer, but from Canada?
Great question, great question. Ken, this question bothers many of H-1B employees, because they are always concerned about keeping their H-1B status intact. That's the last thing they want to do, is to violate their immigration status. So, if you are sitting overseas, like in your example in Canada, then no immigration laws would apply, because he is sitting in Canada, he is subject to the immigration laws of Canada. So, if he is sitting there and working remotely, it's perfectly in order. It has got nothing to do with the status, and that period would be counted toward physical absence from the United States.
Very good.
And in fact, when you are asking this question, this is one of the solutions to the problem. We do advise, like I said, people can go to their home country, or people can go to just adjacent country and complete that period, absent period requirement, and come back.
Very good.
Yeah.
What's meant by the recapture of H-1B time?
This is another tool, Ken, when you are asking about recapturing of H-1B lost time. What happens is people go back and visit their home countries, or they travel internationally. So that means they remain absent physically from the United States. Let us say a person has been away from the United States during the last 5 years or 6 years for 3 months. So primarily these 3 months physical stay period lost in the United States, that can be recaptured by extending the H-1B petition. So the employer can file an H-1B petition to recapture this lost time. Maybe during this time labor request is certified and I-140 is approved, then he doesn't have to go overseas or to Canada and sit there and wait.
For that matter, when he's visiting his home country, he could be doing remote working.
Exactly.
You know,
absolutely.
And continuing keeping the employer's needs satisfied, and get time that he can recapture.
You are 100% correct. You know, all these H-1B beneficiaries, they are very valuable to their employers, because they are working on certain projects which are very time sensitive. And at the same time, employer understands the constraints of H-1B employee, and they would say, okay, you keep on working on the project, because otherwise they feel in their commitments to their vendors or the person who has given the contract. It works very well.
Yes.
It works very well.
It's amazing how much we can do
Yes.
with the internet and remote working and all that.
I agree with you.
I think we're running out of time, and I'd really like to thank you for coming in and explaining this to our viewing audience, because I know it's of great concern to many of them. Thank you very
so much, Ken. Last word of wisdom. Yes, as Ken said, immigration laws are very complex, very complex. So my advice to you is, talk to a knowledgeable and experienced lawyer if you need any guidance or you have some immigration issues. Thank you very much for being with us. Again, appreciate it.
Thank you, Ramesh.